Today, we will talk about the Equal Credit Opportunity Act, ECOA, and its purpose. The Equal Credit Opportunity Act is a federal civil rights law that forbids lenders to discriminate against loan applicants for any reason other than their ability to repay. Specifically, ECOA protects consumers from discrimination based on race, color, religion, national origin, sex, marital status, age, eligibility for public assistance, or the exercise of any rights under the Consumer Credit Protection Act. The Equal Credit Opportunity Act was enacted in 1974 and is detailed in Title 15 of the United States Code. The Act, as implemented by Regulation B, states that individuals applying for loans and other credit can be evaluated only using factors directly related to their creditworthiness. It prohibits creditors and lenders from considering factors that are unrelated to creditworthiness, specifically, the protected classes outlined in the ECOA. When a borrower applies for credit, the lender may ask about some of the personal facts that ECOA prohibits. Another aspect of ECOA allows each spouse in a marriage to have a credit history in their own name. Still, if a borrower has any joint accounts with their spouse, the accounts will appear on both credit reports. When you apply for a loan or line of credit, ECOA gives you certain rights. Additionally, creditors can't discourage a loan applicant from applying based on a prohibited basis. One common violation of the ECOA is charging higher rates or fees to Black, Indigenous, and people of color applicants. The DOJ has reached settlements with major financial institutions for discriminatory lending practices under ECOA. The Consumer Financial Protection Board writes rules to implement ECOA and supervises institutions to ensure they follow the law. Several other federal agencies share the job of supervising for compliance. Lenders found in violation of ECOA can potentially face class action lawsuits from the Department of Justice if the DOJ or any affiliate agencies recognize a pattern of discrimination. The Equal Credit Opportunity Act applies to all creditors, prohibiting them from discrimination against an applicant based on a prohibited basis during any aspect of a credit transaction. Lending officers and employees can't do anything that would discourage a reasonable person from applying for a loan. The Equal Credit Opportunity Act is a law designed to ensure fair lending practices that applies to all creditors. Understanding your rights under the ECOA can help you avoid or take action against discriminatory lending practices that apply to a range of financial products, from credit cards to mortgages. Here are 5 key takeaways. 1. The Equal Credit Opportunity Act, ECOA, was signed into law in 1974 and prohibits lending discrimination in all aspects of a credit transaction. 2. ECOA makes it illegal for lenders to discriminate based on race, color, religion, national origin, sex, marital status, age, the receipt of public assistance, and the applicant's exercise of specific consumer protection laws. 3. The Department of Justice can file lawsuits under ECOA and the Fair Housing Act if the discrimination involves mortgages, where there is a pattern or practice of discrimination. 4. Various federal agencies enforce ECOA. 5. The Consumer Financial Protection Bureau, CFPB, enforces ECOA for banks, savings associations, and credit unions holding more than $10 billion in assets. Hope this would help. Thanks for watching.